Alrighty folks, we will get started now with our fourth and final panel, and I'll begin by introducing our contributors and then our moderator, and we will get started with the beginning of the end. First, Professor William Baude is the Harry Calvin Jr. Professor of Law and Faculty Director of the Constitutional Law Institute at the University of Chicago Law School, where he teaches federal courts, constitutional law, and conflict of laws. His current research interests include different aspects of the 14th Amendment and the nature of judicial discretion. Recently, he served on the Presidential Commission on the Supreme Court of the United States. Professor Baude received his BS in mathematics from the University of Chicago and his JD from Yale Law School. He then clerked for Judge Michael McConnell on the United States Court of Appeals for the District of Columbia Circuit and Chief Justice John Roberts of the United States Supreme Court. Before joining the Chicago faculty, he was a fellow at the Stanford Constitutional Law Center and a lawyer in Washington, D.C. Professor Robert Leider is Assistant Professor of Law at George Mason University's Antonin Scalia Law School. His scholarly interests are in criminal law, criminal procedure, and constitutional law, especially concerning questions about the use of force and the rule of law. He has written on the law of self-defense, the constitutional allocation of the military power, and gun control. Professor Leider was an Olin Searle Smith Fellow at the University of Pennsylvania Law School. He clerked for Judge Diane Sykes of the United States Court of Appeals for the Seventh Circuit and Justice Clarence Thomas of the United States Supreme Court. Professor Leider earned a BA summa cum laude from the George Washington University, raise high, and a JD from Yale Law School and a PhD in philosophy from Georgetown University. Professor Marc DeGirolami is the Carey Fields Professor of Law and the co-director of the Center for Law and Religion at St. John's Law School. At St. John's, he has taught constitutional law, constitutional theory, criminal law, jurisprudence, law and religion, professional responsibility, and torts. His publications include The Tragedy of Religious Freedom and articles in numerous law journals. Before St. John's, he was a fellow at Columbia Law School. His professional experience includes service as an assistant district attorney in Cambridge, Massachusetts. Professor Christina Mulligan is professor of law at Brooklyn Law School. She teaches internet law, intellectual property law, and trusts and estates.
But I'm here.
Her research addresses efforts to adapt intellectual property law for the digital age, the relationship between law and technology, and theories of constitutional interpretation. Recently, she has written about the Internet of Things, robot punishment, and early translations of the Constitution. Previously, she taught at the University of Georgia and was a postdoctoral associate and lecturer in law at the Information Society Project at Yale Law School. Professor Mulligan earned her bachelor's degree cum laude and her law degree cum laude from Harvard University. Before entering academia, she served as a law clerk for Judge Charles Leto of the United States Court of Federal Claims. Moderating our final panel, we have Professor Sherif Girgis. Professor Girgis is Associate Professor of Law at Notre Dame Law School. His work at the intersection of philosophy and law, including criminal law, constitutional theory, and jurisprudence, has appeared or is forthcoming in numerous academic and popular venues. Prior to joining the Notre Dame faculty, he practiced appellate and complex civil litigation at Jones Day in Washington, D.C., having previously served as a law clerk to Justice Samuel Alito of the United States Supreme Court and Judge Thomas Griffith of the U.S. Court of Appeals for the District of Columbia Circuit. Now completing his PhD in philosophy at Princeton, Professor Girgis earned his JD at Yale Law School, where he served as an editor of the Yale Law Journal and won the Felix X. Cohen Prize for Best Paper in Legal Philosophy. He earned a master's degree in philosophy from the University of Oxford as a Rhodes Scholar and a bachelor's in philosophy from Princeton. I'll turn it over now to Professor Girgis.
Thank you. Thanks to you and to Lexi and to Joseph and Daryl and everybody else who's responsible for me getting a seat at this, much less a seat at this table. Super excited about the panel, so we will go right to it, and we will start with Marc on my right and end with Will on my far right.
Well, at least I was appropriate for this crowd. Thank you very, very much to Sherif and to Bray and Alexander. Thank you for organizing all of this. I'm very pleased to be here and on this panel, pleased to be on this panel as well with scholars whose work I greatly admire. The object of my only partially drafted paper is to explore the value of tradition what it is that so many people find or seem to find intuitively appealing or attractive about tradition outside the law as well as within it. Now, there may be specific reasons to value traditions which I think of as enduring patterns of practice in constitutional interpretation and adjudication, as the Supreme Court appears to think in some of its recent, as well as I have argued, many older statements. But in this paper, I'm not interested in those so much as the invocation or appeal to tradition as such, or more broadly, and what that might illuminate about just what it is that the Supreme Court, or really anybody that invokes tradition, is conveying about its value. Now, that exploration, I think, is worth undertaking for a few reasons. The first, that in listening to some of the presentations at conferences, conferences like this one, and others that I've attended, the appeal of tradition qua tradition is, I have found, generally not intuitively obvious or self-evident to many people with whom I work and have professional dealings. Even in many of the presentations, the phrase that I've heard used here is history and analogy, or an analogical approach. So the word tradition tends to be avoided or elided, and I think its appeal therefore requires a good bit of explanation and defense, and I'm only able to do something quite partial in this paper. A second reason is that perhaps, we'll see, unlike some of my fellow presenters, it doesn't matter too much to me whether the Supreme Court continues to rely on the concept of tradition in this or that case, or instead veers off into a different direction. Now, I recognize that we probably wouldn't be here talking about tradition at all at a conference like this one, but for cases like Bruin and Dobbs and Kennedy and the suite of speech cases that depend upon the concept, and earlier, Timms versus Indiana, and many, many others. But for me, that is a matter to be regretted and remedied. We ought to be talking about it. We ought to be interested in it. The comparatively unimportant reason that we ought to talk about it is that the court has long relied on the general decisional strategy that it seems to be now more self-consciously adopting. But we ought also to talk about it because this way of thinking about interpretation and adjudication, one that depends upon enduring patterns of practice handed down intergenerationally, has had a persistent hold on the judicial imagination, even if in this or that term, or in this or that decade, or even in this or that century, it's a method that may go into hibernation. And finally, I think we ought to talk about tradition, its virtues as well as its vices, in fields of human endeavor outside of the law, in which tradition is very frequently invoked, to see if that might give us some insight about what is virtuous or vicious about it in the law. I myself am particularly interested in the character or disposition shaping features of constitutional theories, and how different methodological commitments, different ways of doing things in this field can influence the character of those adopting these methods. Now, it might be tempting to ascribe invocations of tradition to a kind of mindlessness, but I suspect that appeals to tradition are doing something other than that, so that, for example, when the Notre Dame Law Review says right at the very top of its Symposium page that it, quote, has a long tradition of hosting symposia that bring together well-respected and diverse speakers around a variety of timely and thought-provoking legal topics, close quote, it makes me wonder just what it means to appeal to. I understand that general statements of purpose like this probably shouldn't be given undue weight. Still, it's there, though perhaps now that I've pointed it out, not for long. And the paper argues the Law Review is not remotely alone in the realms of cuisine and cooking. I can't resist a footnote here. How deeply, deeply wrong Gary Lawson was in his description some 25 years ago of excellence in cooking as recipe rule following. In wine and beer making, in carpentry, in pottery, in jewelry making, in embroidery, in so many, many other spheres of human life, including even architecture, including even architecture at the contemporary American university. There seems to be an intuitive appeal in the idea of tradition. And the paper goes on at some length in describing the appeal to tradition in these areas, which is often quite insistent and pervasive. One of the things that the paper argues unifies these disciplines or these areas of human experience is the idea of craft, so that appeals to tradition somehow go hand in hand with or are associated with craft occupations or activities. The paper then inquires what defines what it calls craft traditions, and it lists 3 key attributes. Number 1, craft traditions are concerned with what is useful or functional, whether or not it has innate artistic value. In fact, the paper contrasts craft traditions with art on one hand and science on the other. In these other areas, tradition is only comparatively rarely invoked as a good. Number 2, craft traditions invoke the production of objects and artifacts bespoke, by hand, with talent and skill gained slowly over time, through immersion in the tradition of practice, but made for this use or function only. Craft traditions are not mass production. Well, of course, mass production has its uses. Third, and most importantly for my purposes, craft traditions are defined by the history of past practice of the craft, not history as such, since, as we've heard here today, and I think this is correct, history speaks with many voices, but a retrospectively constructed history manifested in an enduring pattern of practice handed down over time. So craft traditions face backward to move forward. The paper then argues that law is very much like this, and not only Law Review Symposium website banners, certainly legal education is like this, from the doctrinal curriculum, which seems somehow utterly impervious to the passage of time in its staple or chestnut cases or doctrines, to the very idea of doctrine as somehow inherently normative. A second footnote: who but lawyers or theologians speak like this, speak about doctrine like this? Not artists or scientists or philosophers or accountants or business analysts or really anybody else. So back to law schools, think of the standards that guide the evaluation of moot court arguments, standards that depend upon the effective deployment of formal rhetoric. Think of citation practices in legal writing. All seem to depend heavily on individual submission to formal methods and practices that rarely change, or rarely change that much, and that are again transmitted intergenerationally. Judging too. Craft is a term frequently associated with good judging, though just what that means is uncertain. Nevertheless, there are judges famously associated with craft. Henry Friendly, Learned Hand, Benjamin Cardozo, and it's interesting to see that in each of these cases, these judges themselves prized something crucial or central about their work, about the kind of judges they were, about the character of judging as implicating tradition. There are even some quotes from Hand comparing the work of a judge to that of a master chef or a carpenter, hardly following recipe rules. The work of lawyers, too. Professor Brett Scharfs has what I think of as the seminal article on law as craft, but the paper spends some time discussing how, once again, apprenticeship, which I'm told, parenthetically, some are very much in favor of reinstating as a path into the law. But apprenticeship is a sustained exercise in learning by practicing again and again and again in the production of craft objects. So my initial object was to inquire what is appealing in tradition or in craft tradition. What can we take from all of this? I think different sorts of answers are possible, and this is where the paper makes a transition into its second part, a part that I still have largely to write, so I'll be briefer here. One part might be... I exceeded my time.
No, keep going.
Craft traditions are simply the sum and substance of what we now find rational or useful or somehow reflective of our law. But such traditions do and ought to change if at any future present moment we rationally believe that they have outlived their utility. A second answer might be, craft traditions are the way in which the powerful dominate the weak. They are subterfuges for the imposition and perpetuation of unequal relations of power among discrete social classes or classes defined otherwise. And yet a third answer might be, craft traditions are the way human beings manifest an important part of what is excellent about us. As far as I can tell, this is really the core attraction or appeal of tradition. It's a desire for union with and continuity of one's own practices with something more than or greater than one's individual life, choices, and achievements. The paper argues that the very idea of achievement presupposes concepts of valuation extending before and after one's own life. Without that presupposition, I'm not sure that the idea of excellence in human activity would have any meaning at all. It's this response, this answer from human excellence, that I want to explore in the balance of the paper as applied to constitutional law and theory, most of which is yet to be written, and I want to do that by examining, again, the type of character that is fostered by constitutional theory, the character it develops or cultivates in the adopter. I have a brief sketch of sort of the character archetypes that I'm playing with there, but that part of the paper is really too preliminary to say much about. Thank you very much.
Mulligan.
All right, so I'm going to start with what I gather is going to be a somewhat surprising argument here, which is that Bruin is not sufficiently originalist. Despite it saying that it is. You know, it starts quoting Heller, saying we seek to determine the public understanding of the legal text, and then it proceeds to not do that. Public understanding we would associate with the idea of looking for the original public meaning of the Constitution's text, but instead what Bruin says is first we look at whether some regulation fits under the ambit of the plain text of the Second Amendment. It doesn't really elaborate on this, but plain text somewhat stands in contrast with the idea of the text as understood in context, not necessarily plain. And then it says if the regulation is within the plain text, it's presumptively constitutional unless the government can show that it's consistent with our tradition of firearms regulation. We just had a little back and forth in the last panel recounting a disagreement or a question of whether that absolutely requires being able to show an analogous statute or if some other evidence can ever be sufficient evidence of being within the tradition of firearms regulation. But I think from what Jason said and how a lot of the lower courts and a lot of the discussion today has indicated, certainly the dominant, if not overwhelming interpretation of Bruin as is that you need to find a statute, and if that's not what they meant to say at the Supreme Court, I hope they change it in Rahimi. It's possible that they did not get super specific about this because there wasn't clear agreement among everyone, and I think it's worth highlighting just as an example in the opinion. If you notice, they say the 14th Amendment incorporates the Second Amendment against the states. They always say the 14th Amendment, and of course they say this because Justice Thomas at least believes it's the Privileges or Immunities Clause. Several of the other justices believe it's the Due Process Clause. Why? You don't have to resolve it if we just say 14th Amendment. That's a ambiguity or a vagueness that we can identify from our past experience reading the opinions of these justices. Less visible might be other places where things are a little bit vague or ambiguous, where we can't tell from this sort of previous experience with their writing. So the requirement or parent requirement of finding a statute limits the public meaning that we are looking to see what the Second Amendment permits. And that's very different from what we usually look to when looking for original public meaning, where you would look to all evidence of public meaning. What people said, what other people interpreted, treatises, letters, debates, etc., etc. What Brandon said he thought was required in the previous panel. Now, I think given that Rob and Will's paper follows mine, it's worth saying that I think there's a lot of overlap in practice between an original public meaning approach and the general law approach that they have, because given the sense in the culture that the Second Amendment codified a pre-existing right, there's good evidence that there was a general understanding of the nature of that right and somewhat of a rich natural law, common law history behind it, that the general law may well be the law because that was the original understanding of the amendment. But even if that's true, we can't skip the public meaning inquiry of asking what the public meaning was in order to get there. The public meaning inquiry requires asking what the public understanding was, and then after that, if there's ambiguity, depending on your view, constructing what to do next or liquidating. But we only get there if the text, if the interpretation is unclear in some way, so we still need to take that step. So why do I think taking a stronger original public meaning view that takes all the evidence into account, both when looking at the reach of the right, the scope, and any limitations on it, is better? The most important reason is that not all constitutional laws get passed, and I think we haven't talked enough about this today. The primary example I use in my paper to illustrate why it is important sometimes to look outside of the laws that get passed in situations is Michael McConnell's paper about disallowing segregation in schools and whether that was permitted/required by the 14th Amendment. So his essay saying that Brown versus Board of Education was indeed required by the 14th Amendment originally focuses on the discussion, the debates, the iterations of the law that became the Civil Rights Act of 1875. The first version of that statute included a requirement that schools were not segregated. Over the 4 or 5 years that it was debated, over a majority of both houses of Congress at some point took that view, which was synonymous with understanding that the 14th Amendment required it. But because of the 2/3 majority needed in the House for procedural reasons at the time, it never passed. By November 1874, the Democrats, who were less sympathetic to this view, took the House, and so what passed did not include this provision. So McConnell's argument is, it is because of a change in political power that this didn't get passed. But that doesn't change the reality of the fact that all of these people were engaging in constitutional interpretation about what the 14th Amendment required. And if we're only, to look to analogy to the case here, if we're only looking at the law that passed, we're going to miss a whole lot of evidence about what people believed was a constitutional regulation. And we're not going to see examples where a constitutional law didn't get passed because of either a change in political power or for another reason that was unrelated to the constitutionality of the law or the interpretation of the Second Amendment. The other situation where this obviously comes up is when there's a different legal or cultural reason for a law not passing. And this is where the domestic violence issues and domestic violence regulations and laws come in. If it's true that back in 1780, people weren't super concerned with domestic violence because of very different ideas about the private sphere, about the way you regulate relationships within the family, if this just wasn't on people's radar, that's not an interpretation of the Second Amendment. That is something that indicates that we were in a different cultural place then than now. But that is quite parallel, rather perpendicular, to the question of whether a law at the time would have been constitutional. So what happens here, so that's one. We're going to miss useful evidence about what laws might be constitutional if we solely focus on laws which were passed. The other practical negative effect of Bruin's lack of taking an expansive view of evidence or focusing on original public meaning originalism, is that even if it doesn't really require this, we can see from what courts have been doing, how people have been applying Bruin, that it nudges people to, we've heard a lot of different versions of this today, what Fred Schauer and Bobby Spellman would call it overly specific analogies or the wrong level of analogy. Jack Balkin calls as original expected applications of the Constitution. What you think would have been passed or what you would have expected at the time would have been the laws that resulted, as opposed to what laws are actually permissible or required based on an interpretation of the text. And so we see, combined with the fact that there were different legal and cultural situations at the time, kind of just bad results. So the a more expansive original public meaning approach gives us more tools for how to understand what's constitutional and what's not. And here I'm thinking of Judd Campbell's research on the intellectual history of natural law and positive common law in the kinds of contexts of speech and gun regulation. There's a rich world here that we can draw a lot from, that Will and Rob do draw a lot from, and to leave all of that on the table is just a mistake in terms of getting at the accurate answers. Here's where I start to go a little bit away from really getting specifically in the text. Original public meaning, as opposed to what Bruin does, is also better for avoiding what I call constitutional alienation. And that also, I think, leads for better results for, more accurate results for originalism, but also better results in other ways. So what do I mean by alienation? Many people who don't see themselves in the founders, in those who had power at the time, feel somewhat alienated from the constitutional story, from the way we, can get a little touched by the, amazing stuff that happened at the Philadelphia Convention, and et cetera. Bruin, when it looks only at statutes that were passed, focuses on just the part of the public that had political power, not even just the, elite white men in general, but the specific ones that had political power compared to those who didn't. And that action, in a really unnecessary and unforced way, given the larger context or demands of original public meaning originalism, kind of acts to further alienate people who already feel alienated from this constitutional story, from fidelity and appreciation for the Constitution in general, and I think originalism specifically. By doing this, somewhat symbolically, the Supreme Court indicates that the whole public doesn't matter. The whole public's opinion doesn't matter, just the statutes that were passed. Or it presumes that the whole public's opinion was the same as that of the particular people whose actions we can see and evaluate, which in many ways has the same result, right? By presuming it's the same without looking, you're allowing one particular subset to speak for everyone else, and it has the same effect of saying, you're not important, people like you are not as important. If Marc will allow me to take a quote from his essay out of context, he can disclaim the application if he wants. But I thought it was a great quote that applies to what I'm talking about, the act of trying to enfranchise people and bring them into this story of what the Constitution is, what our country is doing. Marc writes, even as the theorist or judge develops and applies a constitutional theory, the theory too shapes the disposition and molds the character of its adopter and user. Right? So if we're trying to cultivate the idea that we're all part of we the people, the act of looking at the whole public, including what women thought, what Black Americans thought, etc., has an enfranchising effect and teaches us that everyone's views matter. I think this is important for two reasons. One is practical in terms of getting correct original results, and one is more about political legitimacy. The practical effect is that when more people of diverse views, of diverse backgrounds, take an originalist point of view or are interested in doing originalist interpretation, the interpretation is more likely to be accurate. Because here's the reality: all of us, no matter who we are, see things with a certain slant, right? There are the issues that we worry about, the things that are culturally salient to us. We have slight differences of opinion about what we see, in text. But when the group of people doing the interpretation are homogeneous, they're more likely to make the same errors. And when the group of people doing the interpretation have diverse points of views and backgrounds, they're more likely to be able to check each other and kind of triangulate the actual meaning from the time. So from a practical point of view, having diverse interpreters, having more different kinds of people interested in originalism and constitutional interpretation makes that interpretation better. And I'm just going to I know we're mostly talking about interpretation, but I do want to briefly say a word about political legitimacy. There's sort of there are two significant narratives at play in society right now. More than two, but the two that I think are interesting for this purpose are, one, the narrative that the Constitution is just irredeemably immoral, it's racist, tear it down. This is, not something we should have fidelity to, not something we should continue to work on and invest in. And another view that sends the message that, this is all of our Constitution. This is all, we're all part of it. We all have something to say. And if you believe in originalism and the Constitution, I think you want that view, the view that this is all of our Constitution and all of our country, to be the more dominant one. And for there to be commitment on the part of many different people to having fidelity to both. And Bruin, unnecessarily and unforcedly, is more hostile to that than it should be, by looking at such a small subset of original public meaning instead of the whole thing. So in closing, what I hope happens in Rahimi is that it returns to a broader, more general sense of looking for original public meaning in both the reach and limitations of the amendment, and that the effect of that will be that future cases are more accurate and that more people are enfranchised by it. Thank you.
All right. Thank you very much for the invitation to come here. I would add that I appreciate the invitation as an outsider, but I think I'm the consummate insider, so I can't give that part of it. All right. So in this article, Will and I argue that the lower courts have misread Bruin, and with that have failed to understand how the text, history, and tradition test is supposed to work. Bruin instructed lower courts, we believe, to decide cases involving the right to keep and bear arms according to the traditional principles of general law. So when the framers drafted the Bill of Rights, they did not understand themselves to be creating new legal rights where none has existed before. As the Supreme Court explained in Robertson versus Baldwin, quote, "Law is perfectly well settled that the first 10 amendments to the Constitution, commonly known as the Bill of Rights, were not intended to lay down any novel principles of government, but simply to embody certain guarantees and immunities which we had inherited from our English ancestors. These rights thus were both pre-existing, they predated their enactment into the constitutions, and they were general to Anglo-American jurisdictions." And so when interpreting the scope of pre-existing rights, the unwritten customary law takes primacy. And this is an important shift from how new provisions are interpreted. So when legislatures have new laws that create new rights, we look to the text as the best evidence of legislative intent. But that's not true when legislatures are simply codifying pre-existing doctrines. So as Stuart Bannard explains, when a legislature is only trying to enforce a pre-existing natural right, the words of the statute matter less than the nature of the right itself. And so to understand the right to keep and bear arms, you can't just go to an 18th century dictionary and look up the words people, keep, bear, and arms. You have to understand the customary law that is being codified. Now this concept is familiar in other areas of law too. So for example, the US Code defines murder as the unlawful killing of a human being with malice aforethought. And if you want to know what separates murder from manslaughter, you can't go to a dictionary from 1948, which is the latest enactment of this provision, and ask, what is malice? The dictionary definition doesn't really bear to its legal meaning. What you need to know is the underlying common law concept of malice aforethought, which separated murder from manslaughter. And it's only with understanding the common law can you understand the meaning of this legal text. Now, to be clear, I am not arguing that the specific text used to codify the Second Amendment is irrelevant. To the contrary, whether the right to bear arms is viewed as a natural right or as a pre-existing common law right, the right itself was generic and underspecified until it was fixed into positive law. And the language that was used to concretize the right could affect the right in its scope. So the English Declaration of Rights, for example, only protected the rights of Protestants to have arms, and even then it was only suitable to their condition and as allowed by law. And you can contrast that language to the Tennessee Constitution of 1834, which provided instead that the free white men of the state have a right to keep and bear arms for their common defense. And as the Supreme Court in Tennessee explained, this language meant that in Tennessee, unlike in Britain, quote, every free white man is of suitable condition, and therefore every free white man may keep and bear arms. But again, the limitation to free white men also reflected that in the antebellum South, free blacks and a fortiori slaves did not have the same political rights. Now, with these concepts in mind, let's look at how cases involving the right to bear arms were decided. So statutory efforts to restrict the carrying of weapons began during the War of 1812. And over the next 50 years, courts had to opine on their constitutionality. The state courts treated the right to bear arms as a general law right. And they routinely said that their state constitutional provisions, the Second Amendment, and neighboring state constitutional provisions were all codifying the same pre-existing right and therefore approximately equivalent. The general law nature of the right to bear arms is most forcefully illustrated in cases in which these courts disagreed. So in 1822, the Kentucky Court of Appeals, for example, held that there was a right to carry concealed weapons because the right to bear arms could not be regulated in any manner. And that doctrine was thoroughly repudiated by other courts, which held that legislatures could restrict the carrying of concealed weapons. Now, these courts were not simply refusing to find that Kentucky's local law Kentucky was engaged in a creation of local law, and that this local law was an unpersuasive interpretation of their own state constitution. They thought the Kentucky court had misinterpreted the right to bear arms, and more strongly, that the Kentucky court had gotten the law wrong. Now, in the post-Erie world, our legal system has lost its understanding of general law. So after Erie, law has to be either national law or state law, and courts have adjusted accordingly. And so state constitutions are often viewed as creating a species of local or state law. And because of that, a kind of legal relativism has set in that courts may look to other states' analogous provisions for persuasive authority, but they still treat those constitutional provisions as separate and distinct from those in other states. And so when they diverge, the state courts often chalk off the differences to different interpretations of different provisions. But again, this is not how courts have traditionally understood the right to keep and bear arms. Courts understood themselves as engaged in interpreting a general law, a right that was recognized across American jurisdictions. So with that, let me ask, how does the general law govern the right to bear arms? And I think, at the risk of elevating two-step tests again, I think there is in fact a two-step test that is the traditional mode of analysis. The initial question is whether the challenged conduct falls within the scope of the right to bear arms. And if the answer to that question is no, then legislatures are free to regulate or even prohibit the conduct, subject to whatever other constitutional constraints may exist, like after the 14th Amendment, laws have to be racially neutral. So courts, for example, did not overturn the complete ban on the possession and carrying of dangerous weapons that did not constitute arms within the meaning of the right to bear arms. However, if the conduct fell within the scope of the right, then a different analysis applied. At that point, the question became whether the legislature had reasonably regulated the right using the police power. And legislation could fail to be a proper exercise of the police power in multiple ways. So first, the legislation could be arbitrary, such that, as one court explained, it does not bear a fair relation to the preservation of public peace and safety. Second, the law could be disproportionate to the legitimate ends that are sought to be achieved. And perhaps most importantly, the law could eviscerate the core purpose of the right, in which case the law would amount to a denial or an abridgment of the right, rather than a mere regulation. These principles explain why laws restricting the carrying of concealed weapons were a valid regulation of the right to bear arms. Laws that prohibited concealed weapons merely regulated the manner of bearing arms, and individuals in these jurisdictions could still exercise their right by bearing arms openly. In contrast, laws that entirely prohibited the public carry of arms were generally considered unconstitutional. Even if the government had legitimate public safety concerns about regulating weapons in public, it could not pursue those aims by completely nullifying the right. The police power allows for the regulation of rights, but the power to regulate was not the power to prohibit the exercise of rights. And so this brings me to my last point before I will turn it over to Will. We think the problem in the lower courts today is not Bruin's test, but how lower courts have understood it. Lower courts are attempting to analogize by looking for specific framing error analogs. For example, courts are deciding cases involving assault weapons by trying to determine whether assault weapons are sufficiently similar to Bowie knives, or whether nunchucks are sufficiently similar to handguns. And courts are handling restrictions on carrying arms in sensitive places by going place by place to see whether early American law had a specific analog. Some courts have also rejected regulations that have no framing error analogs, such as bans on firearms with defaced serial numbers, which we heard about in the last panel. This approach, we believe, is wrong. So analogies are only helpful when someone has an underlying theory about how to identify the relevant similarity. And in a judicial case, we think that identifying that similarity requires the judge to discern the underlying legal principle that governs. So for example, the courts that have upheld the restrictions on Bowie knives, for example, courts have routinely upheld restrictions on Bowie knives and small handguns. But they have done so under the legal theory that these weapons were particularly adapted to criminal purposes and they had no legitimate public defense value. So if one were to apply this principle to an assault weapons ban, it should result in invalidating it. Unlike Bowie knives, rifles designated as assault weapons are weapons that have public defense value. Indeed, they are often defined by virtue of whether they are adapted to public defense applications, such as whether the rifle is capable of accepting a bayonet. Banning a musket in 1791 because it could accept a bayonet would have been obviously unconstitutional, and I don't think the passage of time changes the legal principle, at least to the extent that bayonets remain in common service. In contrast, lower courts are invalidating bans against many other weapons of personal conflict that have no public defense value at all, such as nunchucks and switchblades. And the traditional law that would have invalidated an assault weapons ban would have also easily upheld the bans on these kinds of weapons as not, because these weapons are not arms within the meaning of the Second Amendment. And I won't go through in detail for time the sensitive place questions which we discuss in the paper, but I will say briefly that we don't think the proper approach is to go location by location. The proper approach instead is to apply the traditional legal principles. Do legislatures have a proper reason for prohibiting firearms at these locations? Are the locations narrow enough not to completely eviscerate the right to bear arms in public? A ban on having a weapon in a museum is likely easily constitutional whether or not the framing error had that kind of restriction. In contrast, a ban on carrying loaded firearms in vehicles or on all private property is not. And the validity of the restriction on guns with defaced serial numbers, I think, is an easy case. The law infringes the right of no one to keep or carry any type of weapon. It just prohibits the defacing of the gun in a manner that makes it peculiarly useful for criminal purposes. It is a quintessential police regulation. And with that, I will turn it over to Will.
Thank you all. As the last speaker, I'll attempt to be brief. I think we are the only writers for the symposium whose thesis is Bruin is fine, actually. So I just have a couple additional comments to make about that. Rob has already given a sense of what we think is the general structure of pre-existing rights in the general law and the Constitution. I'll add that for those who want to read even more about that than the pages we are going to publish here, I have a co-authored article with some different partners in crime on the role of general law in the 14th Amendment and the idea that the privileges or immunities of citizens of the United States were the general law rights of citizenship. That's with Judd Campbell and Steve Sachs. That sort of further details the idea and application of some of these concepts. But I just want to make two additional points, or answer two additional questions. One is this really what Bruin says, rather than what you guys wish Bruin said? And two, where do we go from here? I'll say, if you're armed with these concepts, and you go back and read the sort of crucial methodological discussion in Bruin, pages 18 to 22 or so, I think a lot of this stuff actually sort of jumps off the page and makes much of the discussion make more sense. Right? The court says, all right, we've got to be originalist, we've got to look to history, we can't just stop with the text, we've got to make sense of all these historical rules. We know the text is sort of locked in the past, but also changes over time. The task of us is to figure out what kinds of changes count and when, the sort of standard problem we've all been wrestling with. How are we going to solve this problem? We're going to use analogical reasoning. We're going to turn to the idea of analogies and ask, when is something like these things we have from the past? Then they recognize the obvious problem that you can't just do analogical reasoning in a vacuum. You need some principle for what factors are we looking for in these old regulations, right? What is the principle of relevant similarity? Do we just care that all the regulations were green, or do we care what they're trying to do? They say we need principles of relevant similarity. Here are some, how and why the right was regulated. There might be others. And the principles they're describing there and calling upon us to use are the principles of the general law, the general right to keep and bear arms, the general police power purposes for regulating it, and the method of the common law in putting those two things together. How strictly was the right regulated? Was it a total ban, a ban on time, place, and manner, something else? What was the purpose of the regulation? And they're just asking for the application of those concepts to the historical materials. I think part of the confusion comes from two things. One is that the court can't be quite explicit about the fact this is what it's doing. Part of that is because the court decided in Bruin not to call for supplemental briefing on whether to overrule Erie Railroad, which admittedly might have seemed like a heavy lift. As Rob mentioned, we live in a world where the vocabulary of the general law is not the way the court normally talks, although as others have pointed out, the court sometimes rules in ways that make clear they still use these concepts all the time. So they're denied the most natural way of accessing these concepts by actually using the legal vocabulary of the 19th century. And they can't even call it common law reasoning, because at this point, common law reasoning has become branded in constitutional law as a form of living constitutionalism, ably defended by my colleague David Strauss. So were the court to say, just look at these and apply the common law, people would say, oh, you mean judge-made law, where they'll just take all the historical examples and then decide whether they want to change the law in big or small ways. So they can't even quite call it the common law. What they're doing by using analogical reasoning and the basic problem of the principle of relevant similarity is they're just reconstructing the common law method without using the words. It's like the game, probably nobody plays it anymore, Taboo, where you have to explain a word to your teammates without using the 5 most relevant words to explain that word. That's what the court is doing. It's trying to re-explain the general law method without using words like general or common and the like. But it's just breaking that concept apart and re-explaining it. The other thing that might make this seem a little not obvious is that the court is at pains to reject something it calls interest balancing. and yet then is introducing a form of reasoning that seems to call for interest balancing. A problem we've discussed before about, to what extent, how can the court have it both ways? But as Rob said, it's nothing wrong with two-step tests as long as they're the right two steps. And similarly, if you look at the ways the court rejects interest balancing, it actually has a bunch of useful adjectives. It's against judge empowering interest balancing. It's against independent interest balancing, independent from the interest balancing called for by the Second Amendment. They're again trying to say they're against this newfangled 20th century thing called common law reasoning, but in favor of this classical form of reasoning called general law or common law reasoning. They're just deprived of the vocabulary to easily say that when they say, don't do this new thing you've been doing. Don't do the thing you've been trained by post-realist law schools to do. Do the thing that is a deeper part of our history and tradition, namely reasoning by general analogical principles according to the common law. All right. In our further effort to be all things to all people, I won't do this all, but I do think seeing Bruin this way, I do think is the right way to see it, answers a lot of the criticisms about Bruin. The need for a principle of relevant similarity, the need for a level of abstraction, the too easy way to manipulate the different categories of abstraction, the sometimes reckless and clueless things lower courts have done in both directions in interpreting Bruin. I think all can be disciplined by reading Bruin as a common law and general law opinion, as I hope the Supreme Court will tell us later this term in Rahimi. And it also gives a good clue about how to approach a case like Rahimi without having to back away from Bruin at all. Right? What the court can say in Rahimi is, all right, it's now time to spell out with a little more specificity what some of these common law principles are. This case calls for one. My guess is the court will adopt a principle already defended at great length by then Judge Amy Coney Barrett, the dangerousness principle, that one of the principles on which the government can regulate the right to bear arms, perhaps even deny it entirely, is that it can prevent dangerous people from using firearms. That's the principle that justifies many applications of the felon in possession statute. Maybe not every application. The court can decide to what extent it wants to deal with that on a categorical or as-applied basis, and apply the dangerousness principle to 922G8. Presumably what it will say is that the statute cannot possibly be facially unconstitutional because some applications of the statute literally call for an individualized finding of future dangerousness. Now maybe even some of those applications have due process problems depending on what the burden of proof is and how well they're proved and so on and so forth, but it cannot be facially unconstitutional, which the Fifth Circuit said. Presumably it could still have many unconstitutional applications, maybe even all of 922, the second half of 922G8, which does not call for a finding of dangerousness. Maybe even the whole second half is unconstitutional, maybe not, depending on how many as-applied versus facial challenges the court wants to entertain. But regardless, the court can do the basic job of saying, don't go looking only for domestic violence statutes or the scope of old surety laws to decide what modern domestic violence statutes are constitutional. Apply sensible common law principles according to the basic principles of Bruin we had. Go forth lower courts and do Bruin better. I'll add, of course, when you have the common law, it often takes several decisions to really work the principle out. So it would not be surprising, or really even the court's fault, if the first attempt to remind us of the existence of a common law principle requires a couple more applications from the court before everybody gets on the same page. Bruin itself was trying to jumpstart the courts into taking Second Amendment rights more seriously. They thought they basically abdicated under intermediate scrutiny. The Fifth Circuit's certainly taking Second Amendment rights seriously, and now needs to be told, to maybe take them a little less seriously, or to read them at a slightly more nuanced and lawyerly level of generality. But I predict that is what the court will do, and it will remind us all that Bruin is fine, actually. Thank you.
Great, thank you. So I'll ask one question of each, and you should also feel free at the end to just append whatever responses or thoughts you have on the other panelists' talks, and then we'll go to Q&A. So for Marc, first of all, I should say as a preface, you should read Marc's writing on traditionalist interpretation, which has really become the point of departure for modern contemporary discussions of that issue. But partly because of that, what most struck me about your piece and your speech just now is that you seem to switch to a different target of analysis. So you weren't talking about traditionalist modes of interpretation, or tradition as a mode of interpretation in constitutional law. You were talking about legal practice itself as a tradition. So the way we learn, the the law, the way we hand it down, the way we write our briefs, the way we make arguments in general, are themselves a set of practices that we received, that we're called to hand on, that call forth excellences in us, etc. Which is different from saying what judges do is consult tradition to decide what, the Interstate Commerce Clause or the First Amendment is. So the question is it possible in your view, and I've wondered about the relationship between these two things in some of your other writing where it's a little more latent. Is it possible, is it coherent to think, yes, legal practice is a tradition, and it's good that it's a tradition because it calls forth these excellences and it creates a continuity and it connects us to others, while also thinking that constitutional law is not traditionalist and in fact that it would be bad for it to be traditionalist? Or is it the case that once you appreciate that legal practice is a tradition, you realize that tradition element seeps through into the way constitutional reason is done?
Now, you want me to?
Yeah.
Okay.
If you
Yeah.
want.
No. So for me, it's more the second view. And the point of this paper, and thank you for saying the nice things that you said, is to try to think about what it is that when people seem to invoke this word, they think is good. They like, or at least many people like, or many people like, maybe not at this conference, but else, like in places, people seem to like this. And what is it that they like? I think, and it came home to me actually when Professor Leider was talking a little bit about malice, and to understand what malice is about. As it happens, I've written a paper about malice in tort law and in criminal law, and I think Professor Leider is right that what the discovery, what the thinking about malice, a concept like malice, depends upon is looking to see what other people have done, what people have done over the years that is continuous and that makes a person understand a particular word, gives us knowledge, let's say, about what that word means. That knowledge, from my way of thinking, just as it is in craft knowledge in other contexts, is derived from practice. Now, it is true, I agree with some of the comments that you need a kind of a, perhaps you could call it a low-level explanation for what it is that unites or binds the practice, but my view is that you can get illumination from other areas, similar kinds of areas that depend upon practices either for knowledge creation or excellence, understanding what's good or what's bad on the basis of practice. So I think, sorry for the long one, but the second is more like what I'm trying to say.
Good, thank you. Christina, I have a question for you, which is basically to put you in conversation with Rob and Will's paper, which is basically, does it fall to the same objections you're raising? So I understood your point about Bruin, or one of your points about Bruin, to be, if the Bruin test is supposed to be tracking original meaning, it fails. And it fails for two reasons at least. One is that the lack of a regulation in the past doesn't mean that people thought it was beyond the original meaning. They could have had other reasons not to create it. And second, a focus on regulation points us to the understanding of the meaning that a subset of people had, the politically powerful, and not everybody else. But if I understand their proposal right, and we're about to find out if I have understood their proposal right, they think, no, there's a much tighter connection between the law and practice here. It's not that the practice is evidence of original meaning, in which case your points apply. It's that the practice constitutes the right. And so the reason we ask about what practices existed is not because it's evidence of some further thing, but because it contributes to the principles that were enshrined. And the reasons we care about, the reasons it's okay to look just at political practices, even though only white men created them, is not because we don't care about the opinions of others, it's because that's not what creates general law.
So I generally agree with the upshot of Will and Rob's paper, but because I think you can get there through original public meaning, right? So I think first you have to say what was the public meaning of the Second Amendment, or later as applied to the states, the 14th Amendment at the in context. So I think when you're talking about New York, you need to do 14th Amendment. and that there is good evidence that people generally understood this as protecting a pre-existing right, in which case then we then look to the content of that right, people's understanding of that right, to fill in what that means. Even though that means you're going to be looking at legal sources, you're not skipping the step of asking what the public, at the time the Second Amendment and the 14th Amendment was ratified, thought the amendment meant, and that's the crucial inquiry. And if you're doing that, you are enfranchising all of the members of the public as being part of what constitutes, or their views being part of what constitutes the original public meaning. So I think in this case, the public meaning points to the general law application, but we can't skip the step of looking for what the public meaning was, if that's what you think courts should be doing, which I think that's where we depart a little bit. The last note I want to say on Bruin is fine actually is, I agree, if it seems like people were doing what you guys said, I would think it was fine actually, but I don't know if it's fine if everyone's so confused that they're misapplying it. And so would an amendment be possibly, if it goes the way you hope it will go, Bruin as clarified by Rahimi is fine actually.
We're trying to fix it.
It's already fine.
Good, okay, and then, so that's very helpful. And striking also, Will and Rob's paper is, I think, the first paper I've read by academics of any political stripe that's a defense of Bruin. And so one question is really whether it's a defense that would be welcomed by the authors of Bruin. So in particular, I'll ask you two questions and you can divide them up however you want because there's two of you. So one question is, you've emphasized the things that would not have to change for them to fully double down on your general law reading of their own opinion. And one thing I'm wondering is how much would have to change, and would it be a tolerable cost to them? So one point that you make, and you mentioned it, Rob, in your talk, is that the one thing that was absolutely clear about the general law of the Second Amendment, that was codified by the Second Amendment, is that it was a right to military-grade weapons, not to, or to the kinds of weapons that are useful in the military and public defense, not to the kind that are in common use by private parties. And that seems to be an exceptionally unpopular view of the protections provided by the amendment on the right as well as the left. So do you think that, since that's the one thing you think the general law was absolutely clear on, do you think if they adopted your approach they'd have to change on that, and is that realistic? Another point is that, and this goes to whether this is really a fair reading of the opinion. One thing that seems possibly inconsistent with the approach is that you described is that they seem to discount evidence the later it comes, which sounds like they're treating the practices as evidence of original meaning, which peters out. Now maybe you'll say that's right because later practices are less good evidence of the general law right, which was fixed at ratification. And so one question I have there is whether the general law included principles of change that would allow the substance of the right to change over time. So would they have to embrace that implication, or would they have another way of squaring their resistance to later practices? And then the second question, believe it or not, that was only one. The second question is on the, not can they pull this off, but would they be proud to embrace it? Or would they be ashamed? Can you say more about why it's not David Straussian common law constitutionalism? Because, Will, I think you're right that that has been understood as one of the, to the extent that there is a theory on the other side of originalism, it's something like common law constitutionalism. And it sounds like what you're talking about here, at least it will sound like that to people, children of Erie, which includes all of us. So in what ways is it different? What kinds of moves would he be okay with that you think are clearly not okay?
Okay. I'll start with the second question. So I think common law constitutionalism from the University of Chicago Law School, from David's office, is judge-made law, usually proceeding by small steps, and proceeding only in big steps if there's a big justification. That's the basic, that's the common law method he described. It's the common law method of McPherson versus Buick, where the court first abolishes the doctrine of privity in tort law, on the grounds we've sort of been creeping there for a little while, and now it's not that big a step. I think that has two features that the court is trying to get us away from in Bruin, and that the general law would take us away from. One is the idea that it doesn't really matter where you started. That as long as you you just look at wherever you are and you kind of wander wherever you want without worrying about what principles it started with. It's just a matter of what step you are in the game. And the other is that the judge is the one in charge of driving the doctrine there. It's a very post-realist way of thinking about the judge's role, as sort of the judge is given these cases and then asked where can they move it. And even somebody in the traditional Judge Posner we talked about earlier saw himself operating in that mode. He had views where he wanted the law to go. There were times he could get the law there were times he couldn't get the law there, but that was sort of the idea. I think the court is trying to call upon neither of those things. It's calling on judges not to engage in their own independent judgments of where the law should go, and not to think only about where we are now, but to think about where the principles came from all along. And in that sense, it's much more consistent with the kind of originalism that we've come to know and love from the court.
Okay, and what would change? I mean, I think there are two sets of answers to this. Set number one, I think in a certain set of cases, the judgment lines aren't going to change, but the justifications for those judgment lines are going to change. And so I think, if you look at, for example, Randy Barnett's been very critical of the Dobbs opinion, saying it's a substantive due process opinion, not an originalist opinion. And I think it's that way because they were, taking in the precedent that they had. But you could take a lot of what Dobbs says and translate it to a kind of general law pre-existing right approach, and it would work. So, the judgment may accord with originalist principles even as the underlying rationale does not. I think there are a second set of cases, as I mentioned, where I think the courts are just getting it wrong. I mean, I think analogizing assault weapons to Bowie knives is a perfectly reasonable analogy to draw. If you're drawing an analogy of weapons that are causing public mischief and you're banning a limited class of weapons while leaving a lot of other weapons. That's a perfectly reasonable line to draw. The problem is that it doesn't accord with the general law principles, and it doesn't accord with the kind of teleological purpose behind the right itself. The right itself speaks in military language. And so, now, would they invalidate an assault weapons ban? I don't know. I think this is one issue they have not wanted to touch, and they really don't want to touch the machine gun ban. But they don't want to go either, they kind of made it clear they don't want to go either way, and they're happy to let the lower courts decide this until they have to. I would say that there are a couple of things on the assault weapons side. Number one, finding an arm to be constitutionally protected doesn't mean you can't regulate it. It means that the regulations are subject to the limitations of a traditional police power analysis rather than a full power to ban entirely the class of weapons. But they can still regulate the weapons short of a full-scale prohibition. And the second thing is that without minimizing the kind of public terror that mass shootings have caused, if you look at what is actually driving our criminal violence, it is by leaps and bounds handgun violence. And so the irony is that the weapons that are most suited for public defense purposes are also the weapons that are least likely to be used in crimes. And so I don't think that the shift, if it happens, would be that detrimental to public safety. But I do think that the court, one of the criticisms of Heller, and I think it's valid, is that it runs in danger of divorcing the operative clause from the prefatory clause. And Heller says, well, the passage of time has done this, but the passage of time didn't do this. Heller's interpretation of which arms that were protected did that, and that was not a necessary implication of the right.
Great, thank you. Okay, everybody else. Fred.
So a methodological question to Will and Rob. The question is, can you clarify how you get to the idea of general law? There are two possibilities. One, the language of the Constitution demands going somewhere else because it is technical. For example, the letters of marque and reprisal clauses. Nobody, to the best of my knowledge, ever talks about letters of marque and reprisal in ordinary talk. The Constitution says, this is technical, you have to go somewhere. Alternatively, there is language that is susceptible to a technical meaning, but is also susceptible to a non-technical meaning. That is, it permits going elsewhere, but unlike letters of marque and reprisal, it doesn't demand it. It looks to me as if the Second Amendment is of this latter variety, and if it is of this latter variety, don't you need some form of originalism or historical reference to get there in the first place?
I think the answer is yes, you need some form of original historical reference. But I think this is at least a case where many of the different methods of originalism all lead you to the general law. So I think the right to keep and bear arms is something of a term of art at the time. There's some discussion in Heller about the fact that people bear, the right to bear arms is not just a sum of the right to bear and the definition of arms. That might already make it more like letters of marque and reprisal than it seems to us today, because it's, we're just less familiar with it. I do think the original public meaning makes it pretty clear. The people who were demanding the Bill of Rights in the original Constitution did not see themselves as demanding some new right they were codifying for the first time in the Constitution. We're finally going to have gun rights in this country. They saw themselves as demanding the instantiation of what they thought was a common law and long-standing right. So if we care about the public meaning, I think that's true. I will add, if you are an original law originalist, which is the correct form of originalist, you could even proceed one step easier and just say, our law today is whatever the law at the founding was, plus any lawful amendments and changes. If our law at the time of the founding included general law principles of interpretation against which the Constitution was read, and nothing has lawfully taken the general law away from us, that remains our law today, and you don't have to call that public meaning.
But if you are like me, for example, a non-originalist textualist,
yes,
this doesn't work. You need something else to get there.
I will add, if you are a non-original textualist, in many cases the operative language will be the privileges or immunities of citizens of the United States. Surely that's like letters of marque and reprisal. It's not a phrase about which lay people have a strong intuition, or could even fully understand.
Others? Derek?
So here, what exactly is general law? I mean, the civil jury is not, to my knowledge, part of the law of nations, as Justice Story would have put it in Swift versus Tyson. A lot of the Bill of Rights were not part of our Anglo-American tradition. The Third Amendment, because they were quartering troops, the establishment of religion, because there was a Church of England. So is this some third layer between local law and general law, generally means Anglo-American background principles? Or is this a new gloss on sort of the Swift era general law in the modern era? Or is there just some link missing from this piece?
Okay, so the general law rights of citizens are most easily stated in Corfield versus Coryell by Bishop Washington, which describes a set of general rights of citizens that are generally thought to be common to Anglo-American heritage. That's already one level down from the law of nations. Okay. There are lots of countries that don't have the same Anglo-American rights that we do. I think it might be true that not everything in the Bill of Rights was a general law right. The Bill of Rights is a mix of incredibly specific positive procedural rights that were just worth, spelling out or coding for the first time. Maybe the Third Amendment's among them, although the Third Amendment has enough property rights things going on, I'm not sure. And general law rights like the right to speak, the right to bear arms, the right to property, and so on. But the passages and formulations the court uses are things like, the rights that have been recognized as the rights of citizens from time immemorial. It's not that different from the phrases the court uses in Washington versus Luxembourg, interestingly, which goes to Rob's point about some of the reasoning still staying in today.
And I think to some degree, some of the, as each jurisdiction codifies it, there are some changes. So the percentage clause in the jury trial right in the Sixth Amendment, I think, does not descend, from common law, but is a mixture of common law as adapted to the American condition by requiring it to be in the state and district.
Okay, one more. Don't go. Oh, Bill is, whoever Bill is pointing to.
I was referring to something else.
Oh, all right.
But my question is, I guess, for Marc and Professor Mulligan together, which is the idea of craft being drawn from tradition takes its power, I think, from a community. I don't care about craft beer, but I have colleagues in this room who go gaga over craft beer. I'm not part of that community that adopts the importance of tradition in that context. And so what are we supposed to think about in a system where we have lost our any shared understanding of what our community is that should give power and weight and credence to our traditions or crafts drawn from our shared history?
So I think this is more of a political than a legal question in a certain sense, or we're at that gray point where they like merge together and they're very fuzzy. But the thought that comes to mind is, you know, we're in this quite polarized time where what's most salient is what's different between people. But I think there have been other political times where what you're always looking for is where can we compromise? Where do we happen to agree? Then we can move something forward. What are the commonalities that we want to focus on versus the differences? And I think the way forward is to try to move away from our current place and go back to the what do we have in common, what can we get behind, what are we all working towards, and to sort of see ourselves as one polity again. And so that's why I think I do tend to find some, I find the kind of theological-ish versions of thinking about the American founding very compelling. For this reason, as a story that we can get behind by adding people to the people as time goes on and coming to this sort of shared narrative of like what we're all trying to do together. It's very hard to do. That's sort of the thought that comes to mind from your question, which is it is a slow cultural process to move from polarization to depolarization and focusing on what we share versus what we don't. And we've all got to choose to work for it as opposed to not.
Just quickly, because now we're over, but one of the, no, not because of you, because I'm going to go on now.
I'll just tell you, I'll interject and say, my vision when you were speaking was of Niedermeyer at the end of Animal House saying, everything is fine. As the chaos around it.
That wouldn't have been the first thing that I thought you would have thought of. But, so one of the features of the approach that I think is attractive, and I have to say I kind of like Bruin too, about Bruin is the post-ratification practices, the continuity of post-ratification practices, but not only those. It's the connection of those practices to, and you can call it whatever you want. You can call it general law. You can, I'll take it, right? It sounds great. But whatever that is, that connective tissue should ideally be found to extend before, during, and after. And I think to the extent that there is no, or increasingly there is no we in We the People, which is I think the kind of question you were asking, no constitutional theory can reconnect that. No constitutional theory can solve that problem. But there are some that might start to kind of heal certain of these fractures, certain of the kind of shattering. And it seems to me that one kind is a kind that tries to create continuities between present and past.
On that note, join me in thanking our...
I'd like to thank the members of our fourth and final panel, and before I give some brief thank yous, I'd like to invite Professor Miller to give some quick closing remarks.
Thank you, Bray, and thank you all again. Thanks to Lexi, thanks to Notre Dame Law Review and Notre Dame for hosting this just amazing panel. Great papers, thanks to all the panelists. I'm going to reiterate a little bit about what my colleague and co-faculty director said, which is there are no interlopers here. I'm very, very serious about this. The center was designed to make this field of law a place of real important scholarly investigation, as has been demonstrated by the thought and care of the papers that have been delivered here. We did this for selfish reasons, in part because we were tired of being the same like 4 or 5 guys in the room, and it was all guys when we started out. And just as you can see, it's a much deeper, a much richer, a much more diverse discussion that we're having. This is good also for purposes of just knowledge production, especially on an area of such significant public importance and interest. And just to tell you how much public interest there is, in the time that we've had this discussion, the Supreme Court of the United States has granted cert in 2 new gun cases, one having to do with the NRA alleging a First Amendment violation by New York public authorities about who they associate with and how they do their business, and the second having to do with ATF bump stocks. So it is a salient issue. Moreover, I will say that I think that the kinds of approaches, methodologies, thoughts that essentially get test run in the Second Amendment and the firearms law space don't stay there. And so, whether it's original public meaning, whether it's the traditionalism, whether it's the marriage of empiricism and constitutional reasoning, I think likely what we see in the Second Amendment firearms law context will migrate into other domains, which some of you might feel more comfortable and certainly more familiar. So in helping develop firearms law as a field, I think we all help public law develop a richer and more sustainable discussion as well. Thank you.
I know folks have flights to make out of the great South Bend International Airport, so I will keep it brief. First and foremost, I want to thank the Duke Center for Firearms Law. When I came into this role back in March, I was very, very blessed to have their proposal land on the top of my pile. I saw it and I was like, oh my God, thank you. And I really, really think that the discussions that we have had today bear that out. This is important scholarship. This is impactful scholarship. This is scholarship that has the opportunity to shape the public law in the way that Professor Miller just said. I want to thank Joseph and Daryl and Andrew individually. You guys have been outstanding partners for the Law Review, and we could not have asked for anything more, so thank you all very much. I want to thank the support staff of the University of Notre Dame and the Law School. I know Nathaniel this morning thanked Ann Kiley, our Student Services Coordinator. We could not do any of this without her. I want to thank our Notre Dame Studios videographers. We've had 2 of them who have come in here to take care of us this long Friday day. And I look forward to you guys being able to see those final products and share these discussions more widely with folks. I want to thank our faculty for coming here and engaging with our scholars. I think that that is the beauty of the Academy in action. I want to thank those that traveled from out of state to come here and listen to these discussions. We are very grateful for your presence here on campus, and I think that that speaks to the quality of the scholarship that we will be publishing. 2 last thank yous. The first to our fearless editor-in-chief, Nathaniel, and to the rest of the executive board. We could not do any of this without their support. And to Lexi in particular. I am all over the place sometimes, and if it were not for Lexi, we would not be sitting in this room today. Quite literally would not have come together without her. She has been working behind the scenes, responding to dozens and dozens of emails, and dealing with my many idiosyncrasies, for which I am eternally grateful. And lastly, to our contributors. You guys have written and are writing some really fantastic papers. I know our work is not yet done, but I am so grateful for you guys entrusting your scholarship to us here at the Notre Dame Law Review. We take that very seriously, and on behalf of Nathaniel, on behalf of our executive board, and on behalf of all of the staff of the Notre Dame Law Review, thank you very much, and we very much look forward to publishing your final products in issue 4 this spring. Thank you all very much for attending, and we look forward to seeing you next time.